Hello lawyers, this is lecture 3 on the Supreme Court rules. In the earlier lectures, lecture 1 and 2, we have discussed order 1 and 2 respectively. Order 3 provides for officers of the court, etc. There are total 8 rules in this order. Rule 1 provides that the custody of the records shall be with the Secretary General and Secretary General shall exercise such other functions as are assigned to him by these rules. So, custody of records of the court shall be with the Secretary General. So, two keywords of Rule 1 is custody of records and functions. Now, let's see what is Rule 2. Rule 2 provides for power. It provides for power of the Chief Justice and power of the Secretary General. Rule 2 provides power to assign to the Chief Justice and it provides power to delegate to the Secretary General. Now let's read it. The Chief Justice may assign and the Secretary General may, with the approval of the Chief Justice, delegate. What? And to whom? Well, to an additional registrar, deputy registrar or assistant registrar, any function required by these rules to be exercised by the registrars. So Rule 2 is basically power rule. It gives power to the Chief Justice to assign the functions of the registrar to these 3 registrars. These are additional registrars, deputy registrar and assistant registrar. Same wise, Rule 2 gives power to the Secretary General. He can delegate powers of the registrar to the additional registrar, deputy registrar and or assistant registrar. But this power to delegate is subject to approval of the Chief Justice. This power to delegate is not absolute. You will have to take a previous permission, previous approval of the Chief Justice. Now let's see what is Rule 3. Someone is absent. Alright. The Secretary General is absent. So who will work? Who will exercise his functions? Well, if the Secretary General is absent, his functions may be exercised by the registrar who has been nominated by the Chief Justice. So the key word is absent. Now let's see what is Rule 4. Rule 4 relates to the official seal of the court. And Rule 5 also relates to the official seal of the court. Rule 6, again same, relates to the seal of the court. So Rule 4 provides that the official seal to be used in the court shall be such as the Chief Justice may from time to time direct and shall be kept in the custody of Secretary General. Now let's see what is Rule 5. Rule 5 provides that subject to any general or special directions given by the Chief Justice, the seal of the court shall not be affixed to any writ, rule, order, summons or other process, save under the authority in writing of the Secretary General or the registrar nominated by the Chief Justice. You cannot annex the seal of the Supreme Court on any document wherever you please. No. There has to be authority in writing of the Secretary General or the registrar nominated by the Chief Justice. Now let's see what is Rule 6. Rule 6 provides that the seal of the court shall not be affixed to any certified copy issued by the court save under the authority in writing of the Secretary General or of a registrar, additional registrar, deputy registrar or assistant registrar. So Rule 5 is related to affixation of seal of the court on writ, rule, order, summons or other processes. Rule 6 provides for affixation of the seal of the court to certified copies. So the key word for Rule 6 will be certified copies. Now let's see Rule 7. This is very important to understand the process of listing in the court. So Rule 7 is divided in two sub-rules. Sub-rule 1 provides for terminal list. So the registrar shall keep a list of all cases pending before the court and shall, at the commencement of each term, this is important, commencement of each term, prepare and publish on the notice board or website of the court a list of all cases ready for hearing in such class separately to be called the terminal list. The cases in the terminal list shall be arranged year-wise in each class separately in the order of their registration, and the list shall be updated from time to time. So sub-rule 1 of Rule 7 provides for terminal list. In general, the registrar shall keep a list of all cases pending before the court. When a term commences, he shall prepare and he shall publish on the notice board or the website of the court. A terminal list is basically a list of all cases ready for hearing in each class separately. And cases in the terminal list are arranged year-wise in each class separately in the order of their registration. And it is duty of the registrar to update from time to time. Now let's see what is Rule 7 Sub-Rule 2. Sub-Rule 2 provides for weekly list and daily list. Let's see what it is. See, weekly list will take birth out of the terminal list and daily list will take birth out of the weekly list. Now let's read clause 2, subclause 2. From out of the terminal list, the registrar shall publish on the notice board, website of the court at the end of each week a list of cases to be heard in the following week as far as possible in the order in which they appear in terminal list, subject to the directions of the Chief Justice and of the court, if any. Now see the part which relates to the daily list. It reads, and out of the weekly list shall publish at the end of each day a daily list of cases to be heard by the court on the following day. So this is it. You make a terminal list at the commencement of each term. You put the cases in each class separately, arrange them their registration wise and update them from time to time. Then comes the weekly list. Alright. From out of the terminal list, registrar will be publishing list of cases to be heard in the following week. That will be known as weekly list. Again, now come to day-to-day basis. Out of the weekly list, now come what is daily list? Out of the weekly list, at the end of each day, a daily list of cases to be heard by the court on the following day will be published. Now let's come to other two lists, remaining last list. One is advance list of miscellaneous matters, another is daily list for miscellaneous matters. So, in addition, the registrar shall publish advance list of miscellaneous matters. From the advance list, matters will be taken up in daily list for miscellaneous matters. Now the third and last, this is miscellaneous kind of writs, like everything is covered into it. Subject to general or special order of Chief Justice, the registrar shall publish such other lists as may be directed. List matters as may be directed, and in such order as may be directed. Now let's come to the last rule, that is Rule 8. Rule 8 in short provides for registrar's duties and powers. There are total 7 sub-rules. So sub-rule 1, 2, 3 and 4 are registrar's duty. 5, 6 and 7 provides for his powers. Now let's see what is the first sub-rule. In addition to the powers conferred by these rules, the registrar shall have following duties and powers subject to any general or special order of the Chief Justice, namely, first, to require any plaint, petition of appeal, petition or other proceeding presented to the court to be amended in accordance with the practice and procedure of the court, or to be represented after such requisition as the registrar is empowered to make in relation thereto has been complied with. So these are the keywords. Firstly, we have to remember this is his duty. He has to require something. Then the other two keywords are to be amended, to be represented. What has to be amended? What has to be represented? Well, plain, petition of appeal, petition or other proceedings. Now let's see sub-rule 2. To fix the date of hearing of appeals, petitions or other proceedings and issue notices thereof. Sub-rule 3 provides to settle the index in cases where the record is prepared in the court. Sub-rule 4. To make an order for change of advocate on record. Sub-rule 4. To make an order for change of advocate on record with the consent of the advocate on record. Sub-rule 5. To direct any formal amendment of record. Sub-rule 6 provides to grant leave to inspect and search the records of the court and order the grant of copies of documents to parties to proceedings without interfering or dispensing with any mandatory requirement of these rules. So when we have to inspect record of the court, we have to search records of the court. So this is the power with the registrar. We will have to take his permission before doing this, and this all process has to be done in accordance with these rules. Now let's see the last sub-rule, that is sub-rule 7. To allow from time to time on a written request any period or periods not exceeding 28 days in aggregate for furnishing information or for doing any other act necessary to bring the plaint, appeal, petition or other proceeding in conformity with the rules and practice of the court. So this we have to remember, this is very important. The timeline fixed is 28 days in aggregate. Now what for this time has been fixed? For furnishing information or for doing any other act necessary to bring the plaint, appeal, petition or other proceeding in conformity with the rules and practice of the court. Like this is the sub-rule from where those defects which come to haunt us very regularly, they come out of. Now same wise, there is a proviso attached to it. This is also very important. Provided that where the matter filed on scrutiny is found to be defective and a diary number has been generated, one copy of the petition and court fee stamp tendered shall be retained, and the defects shall be communicated to the petitioner. Now see, if the defects are not removed till 90 days from the date of communication of the defects, the matter shall be listed with office report on default before the judge in chambers for appropriate orders. So, sub-rule 8 basically provides for timeline. Its main clause provides for 28 days time in aggregate, and the proviso provides for 90 days from the date of communication. So we have to remember this. So this is basically an important order for practitioners at the court. So this is all for today. Please subscribe to the channel if you really like the video. Thank you very much.